Thank you for coming for this briefing, and thank you both for attending it. I have with me Ms. Victoria Tauli-Corpuz, who is the Special Rapporteur on the right of indigenous people, sitting at my left. But we'll start with a short statement by the independent expert on the promotion of a democratic and equitable international order, Mr. Alfred De Zayas, sitting here with us. So maybe a short statement by you, then by Mr. Tauli-Corpuz, and then we'll take some questions from the floor.
Thank you so much. I'm here for the fourth time, and I'm delighted to be here again. And the report was well received this morning. Of course, those who disagree with it, keep quiet. That has been my experience in the past, that critics of my reports figure, let's not give the guy any publicity, so don't give him a chance. In any event, I wanted to say that all rapporteurs who spoke this morning and our colleagues of the special procedures of the Human Rights Council agree that human rights should be given priority over other agreements, including commercial agreements. There is a customary international law of human rights, and the principle pacta sunt servanda, as indicated by Juan Pablo Bohoslavsky, requires the implementation of human rights treaties in good faith and the interpretation of international investment agreements in the light of the human rights treaties. So you cannot trump human rights treaties by just simply entering into an inconsistent international agreement for trade and investment. And the problem is not the lack of diagnosis. The subcommission on the protection and promotion of human rights back in 2003 produced an entire report, a fantastic report on this issue. And many of my rapporteurs, by the way, since you're taking pictures, I want this picture to be taken. This is a project that Professor Kirk Boyd from Berkeley has launched 10 years ago, and we want this. We want an international bill of human rights or global bill of human rights that will combine all of the treaties. This is something that fits into my message. I have here a number of speaking points that I didn't get around to say before the General Assembly this morning. I wanted to say that private courts are toxic to the rule of law. And happily, there is now a trend in states and in civil society. So 250,000 people protesting in the streets in Berlin 2 weeks ago. And there was also a big event in Brussels last Thursday when I was also speaking before the European Parliament against ISDS, because they and I see ISDS as an assault on state sovereignty, an assault on democracy, and an assault on the rule of law. It is totally unacceptable to allow that the rule of law, that the justice system is privatized by its very ontology. The system of dispute settlement. Any suit at law pursuant to Article 14 of the Covenant on Civil and Political Rights, every suit at law must be decided by an independent tribunal that is subject to transparency and accountability. And the ISDS is anything but that. The ISDS is not impartial, is not independent. You have three arbitrators who assume that they can blithely ignore the principle of exhaustion of domestic remedies, blithely ignore national legislation, even the decisions of the highest international courts, and they decide as if an international trade agreement were a just standalone legal code, and that's the only thing that they're going to apply. That, of course, is contra bonos mores. In international law, there is, for decades and decades and decades, a customary international law and general principles of law, such as prohibition of treaties or contracts that are contra bonos mores, that are against public policy, that are against the ordre public of the state, or even against international ordre public. That is a principle of international law, Article 38 of the statute of the International Court of Justice. The other principle is the prohibition of abuse of rights. In every system of justice, you have the prohibition of abuse of rights. The ISDS is spectacular how it has subverted the rule of law. Imagine the situation in which a country like Uruguay, state party to the Framework Convention on Tobacco Control, adopts measures in compliance with the Framework Convention on Tobacco Control, which, by the way, has something like 180 states parties. And then Philip Morris sues them because they're going to make less profit. Now, you need that the International Court of Justice pronounce itself on the priorities. Clearly, human rights treaties must have priority over commercial treaties. And that I say it, or that Vicky says it, or that Juan Pablo says it, or that Yasairi says it, that doesn't get you results. You need the highest judicial instance of the United States, of the United Nations, to pronounce itself on the priorities. And there's Article 103 of the UN Charter that many people forget. But this Article 103 says very clearly, in case of conflict between the UN Charter, the purposes and principles of the United Nations, and any other agreement, and that means also bilateral investment treaties, that means also free trade agreements. If there is a conflict, the Charter prevails. Articles 1, Articles 2, 55, 56, the entire Chapter 9, entire Chapter 10, entire Chapter 11 deal with sovereignty, with the prohibition of interference in the internal affairs of states, deal with human rights, deal with development, deal with international cooperation, deal with international solidarity. So to the extent that these international trade agreements prevent a state from fulfilling their human rights treaty obligations, they are contra bonos mores. As contra bonos mores, Article 53 of the Vienna Convention of the Law of Treaties, null and void. But once again, if I say it or if Vicky says it, the transnational corporations are going to have a good laugh at it. But if it's the International Court of Justice that says it, then governments are going to be strengthened in their resolve to deny giving effect to arbitral awards that are absolutely outrageous, like the arbitral award of $2.3 billion against Ecuador, because two arbitrators out of the three, the third one said this is all garbage, but the two arbitrators said that the expectation of profit of Occidental Petroleum had been frustrated. Now, the fact is that Occidental Petroleum materially breached the contract with regard to the protection of the Amazon region. But again, you have three arbitrators who think they can trump international law, who think they can trump national law. And that has to end. And the only way to end it is to abolish ISDS. I said in my report, there are a couple of points that I made. I want the ICJ to issue an advisory opinion. I want the abolishment of ISDS. And I want a world conference that can be hosted by the United Nations Trade and Development Organization, UNCTAD, in Geneva. And they should make sure that the 3,200 existing bilateral investment treaties and any future multilateral treaties are either revised or terminated. And there is an old international law principle, the doctrine of severability. That means when one portion of a treaty is incompatible with the UN Charter, is incompatible with international law, is contra bonus mores, what you do is you eliminate it, you cut it off, you sever it. Principle of severability. There's plenty of articles in the jurisprudence and in the press that you can search in the internet on that issue. One last point, the fragmentation of international law. This is something that has developed over the last 20 years that must be cleared up by the International Court of Justice. So without further ado, I wanted to say I fully endorse the report of my colleague Victoria Tauli-Corpuz. In particular, I endorse her recommendations in paragraph 77, 78, and 79. And if we have time, I would like to read out to you 77A, 77B, 77E, 78B, and 79B, which are particularly relevant to this issue. I thank you.
Thank you.
Thank you very much. Thank you very much for being here. Well, I also made my report before the General Assembly in October 20, last Friday, and it was also well received. Almost 10 states responded and asked questions. My main argument is that the human rights of indigenous peoples are very much undermined in the face of bilateral investment treaties and investment clauses of free trade agreements. And I've looked into several of the principles that the bilateral investment treaties have, which are really based on the model, the treaty that was developed by, the model treaty developed by the United States. And you will see in these treaties that there is such a principle called fair and equitable treatment that gives an equal treatment to foreign investors equal to the national investors, as well as the principle of non-discrimination, which also gives equally that right to both the foreign and domestic investors, and also of course the ISDS, no? And I looked at the situation of indigenous peoples, and I saw that there are several cases that indigenous peoples are seriously threatened with because of the impact of these investment agreements. You mentioned earlier the situation in Ecuador, no, where there has been two cases filed by indigenous peoples against Texaco and Chevron, and they won the case, no, and they were the companies are supposed to pay 8.6 billion US dollars to the communities, but this has never come to being because now the corporation Texaco is using the agreements that they have on the free trade agreement between the United States and Ecuador to challenge this judgment, no? And so the indigenous peoples don't receive anything in spite of the fact that they have been suffering from the pollution for almost 20 years. And that's the situation now. The dispute is still going on. The other case is the situation of the government of Peru. In 2007, the government of Peru authorized a Canadian mining company, Bear Creek Mining Corporation, to operate the Santa Ana silver mine. No, and indigenous peoples were concerned about this particularly in Lake Titicaca, which is the main source of their livelihood, and they held a series of blockades and strikes, no. After that, there were 6 protesters killed by the mining company people, and so the government gave the local indigenous communities the power to approve or deny mining or drilling operations in the area. Now, the investor is suing the government of Peru under the investment chapter of the Canada-Peru Free Trade Agreement, and it appears that they will win on the basis of expropriation of their investments. No? So there are indications that will show that the government is going to allow the mine to restart again the operations to avoid the costly legal battle. So that's another case. So there are several cases that I cited in my report, which will show how difficult it is for indigenous peoples to assert their rights, to have their rights to self-determination, rights to their lands, territories, and resources, as well as the right to free, prior, informed consent. No, it's very difficult to have these rights respected and protected by the states, and because the states also will face sanctions, if ever they suddenly use their own national laws to protect human rights and environmental protection. So finally, I'd just like to mention that this is also very much related with the Trans-Pacific Partnership Agreement, which is now which has been approved in October 5, and it's going to maybe come into effect later. But there is a case filed by the Maori of the under the Waitangi Tribunal, saying that the TPPA is going to violate the substantial and procedural rights of indigenous peoples contained in the Waitangi Treaty. And so they are filing a case against this, the way that the New Zealand government willingly entered into the TPPA without even taking into account the concerns of the indigenous peoples, the Maori in New Zealand. So this is just to show how insidious the impacts of these investment agreements are to indigenous peoples, and possibilities for them to even claim redress and remedies are getting very constricted precisely because of this ISDS system. So I'd like to end there. Thank you very much.
Thank you. We'll take a few questions. Maybe we'll start on the left here, and then we'll come to the right. Yes, please.
Thank you very much. I'm Fabiola Ortiz. I'm a Brazilian journalist. I'm a contributor to IPS, Interpress Service, and a website called Diálogo Chino, China Dialogue. So I wonder if you could both comment, Ms. Victoria and you as well. There have been a lot of big infrastructure projects in Latin America, and most of them in the Amazon and affecting indigenous people. So if you could please comment on this, Ms. Victoria. And many investments are coming from China, Chinese capitals. Oil drilling and mining as well. So yeah, what are your concerns about it? Yeah, the right to free prior consultation. And if you could, both of you, make some comments. Thank you.
As far as hard law, ILO Convention 169 deals with free, prior, and informed consent. And that is hard law. But we also have it in the jurisprudence of the Human Rights Committee. We have a number of cases in which we protect the rights of indigenous, not by Article 1, which is the one that normally would be applicable, the right to self-determination, but we have found a way to affirm the rights of indigenous to their culture and to their way of life via Article 27 in the Poma Poma case against Peru. The Human Rights Committee even recognized the right to water of the indigenous population. So there is hard law that can be invoked on behalf of the indigenous. But as far as soft law is concerned, and really you experience moral vertigo when you look at these immoral and frivolous litigations against the state and against the rights of the indigenous. Imagine a state that wants to implement the United Nations Declaration on the Rights of Indigenous Peoples. Now, I could cite any number of articles, but let me cite only Article 32. Indigenous peoples have the right to determine and develop priorities and strategies for the development or use of their lands or territories and other resources. That, of course, with ISDS, impossible, forget it. Article 32, paragraph 2, states shall consult and cooperate in good faith with the indigenous peoples concerned through their own representative institutions, not through puppets, not through mavericks, not through marionettes, but through their own representative institutions in order to obtain their free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, and other resources. So we have here a very weird situation. There is an international human rights regime. There's customary international law of human rights. And then subsequently, states enter into these TPPs or TTIP or bilateral agreements, and then the arbitrators say, I don't care about the human rights treaty obligations. They are outside my domain. So I'm going to apply just the BIT, and that is the only law that applies. You can't do that. That is contra bonus mores. That is against pacta sunt servanda. That violates Article 26 of the Vienna Convention of the Law of Treaties. But, as I said, unless courts are willing to say that, this abuse is going to continue. And the problem is one of intimidation. And the problem is one of finding oneself alone. Imagine that a country like Uruguay has a GDP that is inferior to the earnings of Philip Morris. Now, Philip Morris is far more powerful than Uruguay. And when I say Philip Morris, I say Chevron. And I say Occidental Petroleum. And I'm saying Ethel. And the pharmaceutical industry, which is actually engaged in an endangerment of the right to life. Because by withdrawing or by denying access to generic drugs, you are condemning thousands upon thousands of people to die because they cannot afford the medicine. And it is imperative that the United Nations, in international solidarity, say the right to life trumps all the other rights. And there's even a penal aspect to this. I developed that in my report to the General Assembly. If activities of transnational corporations like Chevron completely devastate an area, cause cancers, cause respiratory diseases, cause infant deaths, and there is a significant increase of mortality in the indigenous communities of Peru and the indigenous communities of Ecuador, etc., etc. You have here a question of Article 6 of the Covenant on Civil and Political Rights. Here, the right to life is engaged. And penal law can take care of that. There's also, in many countries, the right of denial of assistance to somebody in danger. That is a topos of penal law. That has to be invoked. And I dare say for these mega projects that cause thousands and thousands of people to be displaced from their homes. And in the course of displacement, there's force, people get killed. I think that there is an issue of crime against humanity. I think that is statute of the International Criminal Court, Statute of Rome, Article 7, little 1, little k. You can very easily subsume this situation as an assault on the right to life and as a crime against humanity. And I think it's time that international society, and maybe civil society has to do it, demand that these corporations not only have to pay a fine, which they don't even want to pay, but that they also be prosecuted for violation of the right to life and any other articles, because Juan Pablo Bohoslavsky, by the way, published a book recently with Verbitsky in, it's going to come out in English now, a book called Cuentas Abiertas, and it's a book concerning the complicity of enterprises in the dirty war, and the fact that major enterprises, international enterprises in Argentina, delivered the union leaders to the junta to be disappeared and killed. So here is a clear penal responsibility of executives of any number of transnational corporations in Argentina. Thank you.
Thank you. Well, just to say that, all these investments in relation to